Hello friends, in the series on the income tax cases, today we will discuss a very important issue on the registration of the educational institution under section 10 subsection 23C clause 6. This issue came before Ahmedabad ITAT A bench in the case of Parul Arogya Seva Mandal Trust versus Commissioner of Income Tax Exemption, which has been reported in 114 ITR Tribunal at page number 287 and whose judgment came on 26th July 2023. And in this case, the issue before the tribunal was that if an educational institution with multiple objects in addition to the object of the education, then whether that institution is eligible to get the registration under section 10 subsection 23C clause 6. In the present case, the assessee for the assessment year 18-19 applied for the registration under section 10 subsection 23C clause 6. The objects list of the assessee were fairly very large in this case, which were including imparting diploma, degree and master programs in engineering, pharmacy, management, computer applications, ayurveda, homeopathic, medical and physiotherapy center, etc. When the Principal Commissioner of Income Tax were reviewing the objects of the assessee, then he was of the considered view that in the present case, the object of the assessee is not merely the education, but other objects are also there. So, section 10 subsection 23C clause 6 registration could not be given, and the Principal Commissioner of Income Tax, by relying on the Supreme Court judgment in the celebrated case, that is New Noble Education Society versus Chief Commissioner of Income Tax, which has been reported in 448 ITR at page number 594 and which has been decided in 2022, in which the Supreme Court has emphasized on the word solely in section 1023C clause 6. Basically, section 10 subsection 23C clause 6 says that any university or any other educational institution existing solely for educational purposes and not for the purposes of the profit other than those mentioned in subclause IIIA-B and subclause IIIA-D, and which may be approved by the Principal Commissioner of Income Tax, are liable to be registered under section 1023C clause 6. Since in the present case the assessee was having other objects also, so the Commissioner of Income Tax denied this exemption. When the matter came before the tribunal was of the considered view and was of the same opinion which was of the Principal Commissioner of Income Tax, and said that the education connotes the process of training and developing the knowledge of the students by normal schooling. The tribunal said that in the present case, the objects of the assessee in the present case are other than the education also, and the assessee cannot demonstrate by evidence that the scholarship which has been given by the assessee to the various students is for the educational purposes only. The tribunal also said that in the present case, although the assessee has clarified its medical object, but the assessee has conveniently silent on the other objects of the assessee, and due to which the registration under section 10 subsection 23C clause 6 cannot be given to the assessee. So friends, from the reading of the judgment of the Supreme Court, that is New Noble Education Society versus Chief Commissioner of Income Tax, and this case, that is Parul Arogya Seva Mandal Trust, it is very much clear that the assessee can get the benefit of section 10 subsection 23C clause 6 only in case when the assessee has the object only and solely of the education. at the end of this video. Once again, I am repeating the name of the case. The name of the case is Parul Arogya Seva Mandal Trust versus Commissioner of Income Tax Exemption, and this case has been reported in 114 ITR Tribunal, page number 287. The matter has been decided by Ahmedabad ITAT A bench, and the date of the judgment is 26th July 2023. Thank you, friends.